So welcome to this session on data governance and cross-border trade. My name's Eleonor Duhs. I'm a director and barrister law firm Fieldfisher in London. This is a short, roughly 10-minute podcast on a number of issues. So the structure is that I'm going to talk firstly about the UK government policy on data and cross-border transfers. Then I'm going to look at the UK and the EU legal frameworks for cross-border transfers. And finally, the provisions of the EU-UK Trade and Cooperation Agreement, which deal with the cross-border transfer of personal data. So firstly, looking at UK government policy on data and transfers. You may well have heard of the UK's National Data Strategy. The goal behind that, after the end of the transition period, is to build a world-leading data economy. And I've set out on the slide here some of the key policies in the National Data Strategy. And you'll see that there are various missions, such as unlocking the value of data across the economy and transforming the government's use of data. But mission 5 is the one that I want to focus on, championing the international flow of data. So looking in a bit more detail at mission 5, the UK's policy is to develop new and innovative mechanisms for international data transfers, which facilitate the cross-border flow of data. That will then remove unnecessary barriers to international data transfers, and the UK wishes also, as part of this national data strategy, to engage with global partners to promote the free flow of data to and from the UK, and the way in which the UK will do that is to confer UK data adequacy on those relevant territories. What exactly does data adequacy mean? I'm going to come on to talk about that now. So this second part of this webinar is about the data transfer regimes in both the UK and the EU. And those are essentially aligned. Prior to the end of the transition period, the data protection regime, which applied in the UK, was the regime set out in the EU's General Data Protection Regulation, or GDPR. And at the end of the transition period, the UK saved the GDPR into national law and called it the UK GDPR. So the UK GDPR looks the same in many respects as the GDPR. It has the same language, the same articles, but it's a piece of domestic legislation which regulates the processing of personal data. And Chapter 5 of both the GDPR and the UK GDPR deals with international transfers of data. So two of the main ways to transfer personal data from the UK and the EU to a third country is by using adequacy decisions. So I mentioned just a moment ago that the UK is intending under the National Data Strategy to confer adequacy on global partners to promote trade. Adequacy is a mechanism, though, because the UK and the EU data protection regimes are essentially the same. Adequacy is a mechanism found in the EU regime as well, and the EU has conferred relatively few adequacy decisions, 12 adequacy decisions so far, on third countries. Adequacy is advantageous because if the EU, or now, after the end of the transition period, the UK has conferred adequacy on a third country, then the business or the entity in question that wants to transfer the data from the EU or the UK to that third country doesn't need to take any further steps at all. They can simply flow the data freely out of the UK or the EU to that third country. So adequacy decisions really lower barriers to trade and lower barriers to the free flow of data. The other main mechanism is standard contractual clauses, and most data transfers from the UK and the EU are done on the basis of standard contractual clauses. So I'm going to look in a little bit more detail at those two mechanisms now. So The way in which adequacy decisions are conferred is that the European Commission, if we're looking at the GDPR, or the Secretary of State, if we're looking at the UK GDPR, assess the adequacy of the level of protection of personal data in the territory in question. And the test which they apply is the protection of personal data essentially equivalent to that in the UK or the EU? And if that test is met, if the protection of personal data in that third country to which the data would be sent is essentially equivalent, then it can essentially be flowed freely, the data can be flowed freely to that territory without the entities in question having to take any further safeguards or any other steps to protect the data in that third country. So it's a mechanism which is very practical and easy for businesses and other entities to rely on. So how is an adequacy assessment made? This is set out in Article 45 of the GDPR and the UK GDPR, and here are some examples of what the Secretary of State, or in the case of the EU, the European Commission, look at in order to decide whether that essentially equivalent test is met. So the Commission or the Secretary of State will look at the third country's laws and rules governing data protection, the relevant legislation in that jurisdiction to do with public security, defence, national security and criminal law, the respect for the rule of law more generally, human rights and fundamental freedoms and whether they're respected, the access to personal data by public authorities, and that one really is worth remembering because this is where a couple of adequacy decisions come unstuck in the past, and the rules for onward transfer of personal data from that jurisdiction to another third country. So finally, the international commitments of the third country. So those are some examples of the sort of thing that the Commission and Secretary of State will look at in deciding whether to confer an adequacy decision. Data transfers under the UK and the EU regime, so the UK GDPR and the GDPR, are relatively problematic at the moment. So there have been two privacy cases involving the activist Max Schrems. So these cases have been called Schrems 1 and Schrems 2, and they resulted in two adequacy decisions being invalidated. The safe harbour decision, which could be relied on to flow data from the EU to participating US companies, was invalidated in the Schrems 1 case, and Privacy Shield, which succeeded safe harbour, was invalidated in Schrems 2. And the basis on which those decisions were invalidated by the Court of Justice of the European Union, very broadly speaking, were this issue of public authorities' access to personal data. The Schrems 2 case also looked at the standard contractual clauses, which is the other mechanism for transferring data from the EU or the UK to a third country. And the use of standard contractual clauses prior to the Schrems 2 case had been relatively unproblematic. The data exporter would sign them, the data importer would sign them, they'd put them in the drawer and that would more or less be it. But the Court of Justice said, no, that approach is not acceptable and you have to do an awful lot more to ensure that the data is protected when it goes to the third country, when it's sent to the data importer. And so now what has to happen is that companies themselves have to assess those matters set out in Article 45 of the GDPR or the UK GDPR in order to be able to transfer the data. So they have to assess the rule of law in the third country, the national security legislation, the international commitments of the third country. And there is a real question mark about the extent to which companies really are able to undertake these sorts of complex assessments in relation to the third country to which they want to send the data. So that's one problem with data transfers from the UK and the EU. And the second problem is that some of the technical and organisational measures which European regulators have suggested might be useful in order to protect the data are in fact quite unrealistic. So, for example, if a business was to wish to transfer data to a third country, that country's rule of law or national security legislation gave rise to concerns, they could use some extra technical or organisational measures to protect that data, to enable that data flow. But one example, encryption, really is quite problematic, because what the European regulators have said in guidance is that the encryption keys have to stay in the EU. And that really often will undermine the whole basis, the whole reason for the transfer, because if the data can't be de-encrypted during its life cycle, then that transfer really may not actually be of any use to anyone. So these are some difficulties with data transfers following the Schrems II decision. The UK has a dilemma here on its hands because the UK is about to be conferred with an EU adequacy decision, which would enable the free flow of data from the EU to the UK for the next 4 years. That's the starting point. And the UK obviously needs, in order to trade effectively with the EU, its closest trading partner, to be able to do so easily. So standard contractual clauses really are not a particularly helpful mechanism to use for data transfers from the EU to the UK. So adequacy, it really does remove barriers to trade and barriers to that free flow of data from the EU to the UK. And so the UK really needs to keep an essentially equivalent standard of protection as the EU in order for that adequacy decision to remain in place and not to fall into the position of those US companies under Safe Harbour and Privacy Shield that we saw with the invalidation of those adequacy decisions. But the difficulty that the UK has is that under the National Data Strategy, it really wants, as we saw, to champion the free flow of data. And the current regime that the UK has really is quite restrictive. So there is a real dilemma here. How does the UK, on the one hand, champion international transfers of data, but on the other hand, how does it keep that essentially equivalent standard as the EU? How do those two competing interests align? So that's one of the issues that the UK has now after the end of the transition period and being in receipt of an also wanting to build that world-leading data economy. So I'm going to, for the final segment of this talk, look now at the free flow of data under the Trade and Cooperation Agreement. And there is an argument, a respectable argument, that the Trade and Cooperation Agreement provides a more stable basis for the UK's EU data adequacy than we saw with Safe Harbour and Privacy Shield. And I'm going to explain in a little bit more detail how that works in a moment. But the key thing really is that the Partnership Council, which oversees the functioning of the Trade and Cooperation Agreement or the operation of it, can help to give some greater stability to the UK's adequacy decision than we've seen potentially with other adequacy decisions. And the way in which that works is firstly that the Partnership Council is able to make recommendations to the UK and the EU regarding the transfer of personal data. So if there are problems or challenges relating to the UK's adequacy decision, then it may be that the Partnership Council is able to assist with measures which give some greater stability and possibly provide some political solutions to any difficulties that are being encountered. This is quite striking in the law enforcement context as well, because the UK's adequacy decision is actually two decisions, one under the General Data Protection Regulation and one under the Data Protection Law Enforcement Directive. So this is the one that's relevant here in the context of law enforcement. So if the UK was to lose EU adequacy in the law enforcement context, then it may be that some of the provisions of the law enforcement parts of the Trade and Cooperation Agreement could be suspended by the EU following that loss of adequacy. But then there's some interesting drafting here, which sets out again this role of the Partnership Council in potentially providing some greater stability to the UK's adequacy decision. And the drafting here says that the Partnership Council should explore ways of allowing the party that notified the suspension, i.e. the EU, to postpone its entry into effect, to reduce its scope or to withdraw it, which is quite striking because there's the potential here for the Partnership Council to say, actually, if one or two adjustments are made, then the free flow of data under that adequacy decision could still potentially continue, notwithstanding what the Court of Justice may have said about the UK's adequacy. So that may give some greater stability to the free flow of data under the Trade and Cooperation Agreement. As I said, greater stability than we saw with Safe Harbour and Privacy Shield. So some final thoughts then. The UK really needs to achieve a delicate balance in terms of its data protection regime. It needs to keep these essentially equivalent standards to the EU standard in order to allow the free flow of data from the EU to the UK to continue. But also it needs to be pragmatic and flexible when conferring adequacy decisions on third countries in order to allow those trading relationships with third countries to develop. So that'll be an interesting prospect to see how that delicate balance plays out in reality. And second thought is that the Trade and Cooperation Agreement could be really quite positive in providing stability to the UK's EU adequacy decision, which may make it more durable, Safe Harbour or Privacy Shield. Here is some further reading on these issues. Finally, here are my contact details should you wish to get in touch. Thank you very much indeed.